I'm Andy. I run the Magic Center. I'm actually going to have Josephine introduce our speaker today. She's here from the Department of Public Policy that we're co-sponsoring the talk with, as well as affiliated with the Computer Security Department. But I will say, before I turn it over to her, many years ago, Chris and I had the pleasure of being a part of a group that did a project from preserving virtual worlds from the Library of Congress. And it was one of the most interesting grants that I've ever been part of. It was also one of the most depressing grants that I've ever been part of. We got to do a lot of work, meet a lot of great people, come up with a lot of things that we could do to have some impact in preserving the kinds of things that we think are culturally important with respect to multiplayer games and worlds and things. And at the end of it, we wrote this really nice report that we gave to the Library of Congress that basically said, here are all the things we could do, we're not allowed to do any of them. And I expect that you will have a lot to say on why, and hopefully some hope for the future. But I remember doing that work with Chris, and it was a weird place to end up with respect to funding for it. So I'm particularly personally interested to hear this talk today. In terms of the series overall, we have one more speaker that we'll be announcing, so I would encourage you to come back in April. It's also going to be amazing. Hopefully you've enjoyed the series this year. If you have, please let us know a little bit about what you wanted, what you liked, what you got out of it, that kind of thing. The more that we get feedback from the folks that we bring in, the better we can hope to craft the series in the future and keep meeting the needs of the campus. So with that, Joe.
I'm totally thrilled today to be introducing Kendra Albert from Harvard Law School. I first met Kendra 5 years ago. She was co-teaching a class I took in graduate school called Ideas for a Better Internet, all about trying to make the internet a better place, which is still, to a large extent, what she works on. And she's now finishing her law degree at Harvard Law School. She's going to be joining next year a law practice in California, working on computer security and computer fraud and abuse issues for hackers. So those of you in need of legal guidance someday, I would also point you in her direction. She has worked with Cloudflare. She's worked with the Electronic Frontier Foundation, where she co-filed a DMCA 1201 exemption for video game continued use and archiving, which she's going to talk about today. She's incredibly well-versed and has a very deep background in how the law and technology, particularly video game technology, intersect. I personally have wanted to bring her here to RIT pretty much since I got here in September when I was teaching a class on cybersecurity law and policy. Many of you are in that class now. I teach the Digital Millennium Copyright Act, the DMCA. I use a couple examples on video games, and I found myself in September for the first time trying to teach a room full of college students about what World of Warcraft was, what gliders were. Totally not up to the task, as all of my students will attest. And I ran into Kendra at a conference a couple weeks later. Peter's nodding in the second row there. He's right. I ran into Kendra at a conference. I was like, you have to explain to me the difference between World of Warcraft 3 and World of Warcraft and what all of these cases really mean and their depth. And she started explaining to me, and I realized really what I need is for her to come and tell my students about it and tell the rest of you. So I'm incredibly grateful and delighted that she's here today. As I say, she has a deep background in these issues. She also cares really deeply about them in a way that I think has guided a lot of her work. Please join me.
Thank you, Josephine, and thank you, Andy. It's a pleasure to be here, and I'm really, really excited to talk about this. Both because, as Andy and Josephine said, or as Josephine said, I've worked on these issues for a while, but also because I really do care very deeply about them. And I'm really excited to talk to folks who I really would like to inspire to also care very deeply about them. So that's kind of the meta goal of the talk. But I'm going to talk about the history and the future of reverse engineering law, video games, and digital rights management. Those are a lot of words. And in true lawyerly fashion, I'm going to start with some definitions, right? So it turns out that one of the first questions that you have to answer as when you're trying to define an area of law is what is this thing? Well, it turns out when you Google reverse engineering, you get a lot of pictures of magnifying glasses held up to code, and my understanding is that's not the current best practice around reverse engineering, and possibly never was. But reverse engineering is really important to how lawyers think about software and a whole bunch of other related areas, because it actually is one of these things that comes up in multiple areas of law, from copyright law to patent to computer security law, to antitrust, right? And so when you talk about what reverse engineering law is, it turns out that it's not very specific to a particular area. So the same sets of laws apply if you want to learn how engendered physics work, or if you want to attempt to deactivate software to brute force an iPhone pin, not that we would know anyone who is attempting to do that. Or to see how malware propagates, or to modify the balance on your transit card. Again, not that we would know anyone who had ever tried to do that. So when I talk about reverse engineering law, it's difficult because there are so many things that so many legal regimes that all coexist in this space. And I could throw out a ton of acronyms. I could throw out the CFAA, the Computer Fraud and Abuse Act, the SCA, the Stored Communications Act. There are state criminal trespass statutes. There's the Wiretap Act. There's breach of contract claims. There's tortious interference with contractual relations, which I will never speak of again. There's patent. There's trademark. There's copyright. And so where do you even start, right? Well, where I start is with the obligatory disclaimer. I am not a lawyer. As just being said, I'm in law school. I am, more importantly, not your lawyer. And this is not legal advice. So before I tell you what I think the law is, I'm required to say this because I don't want you to get the impression or tell someone that, oh, Kendra Albert told me this thing. But in any case, so when we say reverse engineering law is all of these things, it covers all of this stuff, it's hard to figure out where to start. And so where I start is with copyright law, because I think that is where we see these issues play out for software and for reverse engineering in software in sort of the most direct fashion. It's where you see these contrasts between sort of the public interest and the rights of copyright holders, and it's where you see these like ongoing battles where the sides can keep shifting. So, definitions. What is copyright? Well, so we can start with the Constitution. People may or may not know, but the copyright law actually is part in the Constitution. It's part of the Article 1, Section 8, Clause 8, and grants to authors the exclusive right to their writings for a limited time, right? And so this constitutional right is meant to produce artistic and creative works, and in that, to the end, it covers original works of authorship, fixed in a tangible medium of expression. And then there's a whole bunch of language about how lawyers want to cover their ass. Sorry, I swear. I'm not really sorry about it. So anyway, so there's a whole bunch of stuff at the end, but the important part is original works of authorship fixed in a tangible medium, right? And then there's a whole bunch of specific categories, because lawyers like categories, and I will refrain from trying to have you read this teeny text. But instead I will tell you that one of the things that you could wonder about if you were faced with this list is where exactly software computer code would fit on here. Would we put it, or where would video games fit? Would we put them under motion pictures and other audiovisual works? Could we imagine that they're choreographic? Well, no, the answer is boring. The answer is they're literary works because code is written down. Sorry. And if you're really interested in like why they fit in that category, I would love to talk to you after about why law school is a perfectly reasonable career choice. But in any case, so copyright covers literary works. It covers source code, like this code, which is a C program for computing by factorial. It also covers binary code, like this, which is part of the same in binary. And it seems a little odd that it would cover binary code because, it's not like the person who wrote that C code sat down and wrote this individual binary code, although they could, and, for some people they would. But the fact that both binary and source code are covered is actually really important to the way that sort of reverse engineering law plays out. It's not really about whether somebody really would sit down and write the code this way, but rather it's creative and it's fixed in a tangible means. It's a tangible work. So the code for video games and all software is covered under copyright as a literary work, right? I'm going to say this, it's probably going to be obvious to all of you, but copyright also covers images, sounds, and musical compositions. So it covers our beautiful Angry Bird to our to your left and something like this. That is, protected by the Constitution, that particular sound, for better or for worse. So what does that mean for how we think about reverse engineering? Like, what does that mean for how we think about video games? Because if literally all code that's fixed in a tangible means of expression is covered under the Copyright Act, then, would it like an API be covered? If you're writing the same like header statement at the top of all of your files, is that covered? Is it copyright infringement every time you write static void, just like every other human or every other person who's programmed in that language who's written that? Well, the answer, spoiler, the answer is no. Copyright doesn't cover some stuff. And we can argue about this, but I think that part of the reason copyright doesn't cover these things is because of the First Amendment. It's because there is value to shared cultural language and there's value to people being able to express themselves. So copyright doesn't cover ideas, procedures, processes, systems, methods of operation. I can read the slide, but you can also read it. So what that means is that something like a process by which you fling objects at a structure using a slingshot to make the structure fall down, not covered under copyright. The idea of birds that are angry, not covered under copyright. And you could imagine that there could be an intellectual property system that protects that says Alfred Hitchcock, you got there first, sorry Rovio, you can't market the Angry Birds game, right? But that's actually not how that works. And there are a variety of doctrinal, aka legal, rules and sort of categories that things can fit in when we decide whether they're copyrightable or not, in order to sort of get us out of the pickle that such a broad definition of all of creative works fixed in a tangible means of expression put us in. So the idea expression dichotomy says Angry Birds being flung at something, protectable. The idea of birds that are angry, not protectable. There, you all learned some day 2 copyright law. That wasn't even day 1 copyright law. We already went through all of that. It also means that things like the equations in the physics engine, although the actual written part of the equations may be protected, the sort of basic math behind them, F equals ma, is not protected by copyright law and actually can't be protected by patent either. So that's the other thing. There are other forms of intellectual property. So my goal here is not just to give you a 2-minute rundown of copyright law, but also to tell you that the copyright law is deeply invested in thinking about what isn't, to the extent that it can be invested because it's not an object. People who work on copyright law are deeply invested in thinking about what should or shouldn't be covered, to talk about the trade-offs of what intellectual property is supposed to do. For exactly the reason that I showed you the constitutional clause is because it's supposed to protect the rights of authors for limited times. And so that brings us to our first case, which is Sega v. Accolade. This is a Ninth Circuit case from 1992. And this is a case where we really start to examine exactly what is protected under copyright law and why, more importantly to all of you, why it matters to video games, right? So in Sega v. Accolade, Accolade was interested in reverse engineering the operating system for the Genesis console in order to basically write their own games without going through Sega's licensing system. Sega basically was going to make them pay a lot of money to license their games, and they said, no, how about we buy a bunch of Sega consoles, lock a bunch of people in a room, and ask them to come out on the other side with something resembling something that makes our games compatible with this console. And so the copyrighted work at issue is actually as the Genesis operating system code, and that's both binary and source, as we talked about earlier. And who won? Well, so here's the thing. Sega did have to copy a little bit of Accolade did have to copy a little bit of the actual code that Sega used in order to authenticate the games. But Accolade actually won. And that's because of a doctrine called fair use. So having said all that about what is and isn't copyrightable and sort of the IT expression dichotomy and merger doctrine and all that fun stuff, there's actually another sort of statutory out for how you deal with problems where we really think it's in the best interest of people to be able to use this copyrighted work in a way maybe not intended by the creators or not authorized by the creators. And that's fair use, section 107. As you can tell from this My Little Angry Birds photo, fair use covers a variety of different works that aren't just copyrightable code in video game consoles. But the basic test is actually the same, which is kind of funny, right? We apply the same test to My Little Angry Birds here as we do as they did in Sega the Accolade, right? So I can read through the factors, but I'm just going to sort of boil it down here and tell you that often what comes out as the most important thing for the purposes of fair use is either factor 4, which is the effect of the use on the potential market for or value of the copyrighted work. So is what you're doing competing with the copyrighted work? Is the person who owns the copyrighted work going to lose money because of like the thing that you need? And if you look at this picture, right, is Angry Birds going to lose money because somebody produced this picture of Angry Birds characters dressed up as My Little Pony? The answer is probably not, right? Is Accolade is Sega going to lose money because Accolade copied parts of their console code in order to sell compatible video games without going through their licensing program? I mean, yes, they are. So there has to be something else going on here besides factor 4, and that's actually factor 1. But you wouldn't know it from looking at it because the phrase transformative does not occur in factor 1. But the test actually amounts to this kind of idea of what counts as a transformative work. Are you taking this thing, this copyrighted thing, and are you using it differently than the person who sort of originally wrote it? And in this case, it's probably easier to see for My Little Angry Birds than it is to see for Sega the Accolade, because in Sega the Accolade, they're not really using it that differently. But the court still comes out with this sort of analysis that what Sega the Accolade did was fair use. And this is part of an early set of cases that are referred to sort of collectively by the name of interoperability, right? Because what people were trying to do is make things talk to each other, frankly. And because lawyers are bad at distinguishing between different things that involve computers. So, interoperability and reverse engineering and like software all kind of like fall under the same header of, techie things that are scary. So, pardon us, I'm sorry, as a representative of lawyers. So we have this case from 1992 that suggests that there are circumstances under which reverse engineering an operating system is okay, even if you're using copyrighted works. We have another case involving video games. Sony v. Kinectix, which is from 2000, so it's later. And in this case, Kinectix was reverse engineering the PlayStation BIOS for protecting, for the purposes of emulation, right? So they wanted to create a PlayStation operating system so you could play PlayStation games on your computer. Surprisingly, they were also successful, as in Sony sued them and Sony lost. And part of what happened here is that they took very little of the original copyrighted content. Well, it was basically they actually used none of the code that Sony wrote in their actual emulator. What they did was they only looked at the code. They sort of disassembled it and sort of reran it and like performed like static analysis and dynamic analysis and all of those fun things that one actually does when one's reverse engineering, not just with the magnifying glass. And wrote their own code that did the same thing. And what the court says in Sony v. Kinectix is that although they made intermediate copies of the code, right, they had to like make a copy to run it on their hard drive to see how the code was coming. And in the Ninth Circuit, which includes California, putting a copy of code, running code in RAM can count as a copy for copyright purposes. This shouldn't make any sense. Like, this doesn't make any sense. I realize that that distinction between, oh, it's on my hard drive and oh, I'm copying it into my RAM is one that, for the most part, users have absolutely no control over. And like, this is just not a reasonable place to draw a line between like what is copyright infringement and what isn't. But unfortunately, it's still the case law. So despite the fact that Kinectix did this, right, they made copies of the work in order to reverse engineer it, the court, A, says it's fair use. and B finds that under the essential step doctrine, basically they had to make the copies in order to perform that fair use. Those copies were not infringing. So this is like the background. The confusing, occasionally totally incomprehensible legal background in which reverse engineering exists before 1998. And yeah, I know this case says 2000. If you're curious about why it says 2000 and why I'm saying 1998, feel free to ask me about any questions. Because in 1998, the Digital Millennium Copyright Act was passed. And as the folks in Josephine's class know, but for everyone else, the DMCA, as it is colloquially known, was a congressional act that was meant to codify 2 treaties. And the reason it was meant to codify 2 treaties is that the folks who wanted the MCA, which was primarily the content industries like record companies and movie studios, were not able to get Congress to pass the things they wanted as law. So they went to the World Intellectual Property Organization and got them to write a treaty and then got the US to sign on to it that said that they had to pass the things that the industry wanted. And so magically we got the DMCA. So the DMCA has a lot of stuff in it, and I'm going to focus on one very particular part, but it also contains Section 512, which is the safe harbor provision, which is pretty much the reason that Web 2.0 exists. But it contains, most relevantly to this, it contains 1201, which provides civil and criminal penalties. It has a number of exemptions and exceptions, and it has statutory damages. People don't talk about 1201 that much. People don't talk about 1201 nearly enough, in my opinion. But the thing about the Digital Millennium Copyright Act is like it's one of those congressional bills that has a whole bunch of junk in it. So if you think 1201 is like sort of neglected, I suggest you look into 1301. Does anybody know what DMCA 1301 is? Yeah. So that would be the intellectual property protection for boat hulls. If you want to look at a beautiful example of how lobbying works in the United States, I suggest reading that provision. Anyway, so DMCA 1201, what does it say, and like why have I been spending all of my time getting up to there, right? So this is the statute. It says, and I will read it because you're going to hear me use this language a lot, no person shall circumvent a technological measure that effectively controls access for protected work under this title. Well, so that's like not a model of clarity, even by the standards of congressional statutes. But thank God, Congress granted us, in its infinite wisdom, a couple of definitions. So what does it mean to circumvent a technological measure? Well, here you go. It means to descramble a scrambled work, or decrypt an encrypted work. Thanks, guys. If I'm decrypting the work, then probably by definition it's encrypted, but maybe not. So, or otherwise avoid, bypass, remove, deactivate, etc. Technological measures without the authority of the copyright owner. So, this language initially is focused on things like DVD encryption, like ebook protection, like the things that keep you from copying certain forms of CD. I can't remember the difference between CDRs and CDR plus minuses. I think I'm dating myself. Never mind. It's just going to keep going. That's fine. So we have a definition for circumvented technological measures. There is a little bit more detail about what that means. And then we have a definition for effectively controls access to the work. So if you thought this meant that the security mechanism, the technological measure, actually had to be good at what it did, I have unfortunate news for you, which is that it's not true. It just has to, in the ordinary course of its operation, require the application of information or a process or treatment with the authority of the copyright owner to gain an access to the work. So what that means is it could include like password protection, right? Like that is a perfectly valid technological protection mechanism because the application of information, the password, unlocks the thing. It also includes, DVD encryption, all those things I talked about. Final definition: a work protected under this title is something protected by copyright. So that was a lot of statute. And in the interest of making sure that my talk title and all of my use of Angry Birds is not free riding, I am now going to explain DMCA 1201 using illustrations from Angry Birds. So the pig is the copyrighted work. The wood is the access controls. And bird flinging is a 1201 violation. We're going to start there. So the other thing that's in the DMCA is there are 2 trafficking provisions. I'm only going to talk about one in depth because I find statutory interpretation a bit obtuse at times, so I don't really want to go into it with y'all, so I'm going to focus on 1201A2. So this prevents access, technology that circumvents access controls, and it prevents people from trafficking in it. So to return to our metaphor, the slingshot for slinging the Angry Birds, that's a trafficking, that's a technology. Selling slingshots, that's trafficking. All right, that is like the basics of 1201 in Angry Birds. And now I'm going to talk about like what that means for all of you humans who don't really necessarily care about lawyers explaining technology using games you play on your iPhone. Oh, and also there are a whole bunch of exceptions. There's one for libraries, there's one for security researchers. They're all really narrow. This is the reverse engineering one. I will come back to it. Suffice to say that they are in there, which probably meant that they were helpful to getting the act passed in terms of making certain constituencies feel better about what should have happened. 1201F specifically deals with the circumstances that kind of led to the Sega and Sony case, right? This is pretty specific to a commercial institution that's developing a competing product, right? So the language talks all about like when you're developing a competing product, you can share this information. There's actually like 4 more paragraphs. I just talked to the first one. So it's very specific to what we see in the facts of Sega and Sony. All right. Before we go further, I'm going to do my best to very quickly and in minimal jargon explain how the federal court system works. So we all probably mostly have heard of the Supreme Court. They're pretty famous. But below them we have at the trial level, so when they talk about the jury or like finders of fact, nobody outside of law talks about finders of fact. When you talk about a jury, right, you're talking about a district court level decision, right? This is juries trying to figure out what happened in a case. If it gets appealed, aka one party is like, I'm really unhappy with this, like let's try that again. It goes to what's called a circuit court. So there are 11 courts of general jurisdiction, which is 11 courts that cover states like these, and then the DC Circuit and the Federal Circuit. What's interesting and what's very important for this particular topic about how the federal court system works is that if the Supreme Court has not decided something, then the circuit court in the area in which the lawsuit is taking place is the law of the land. So that can mean that if the Supreme Court hasn't decided an issue, the law, if you're sued in California, can be very different than the law that you're sued if you're sued in Massachusetts or New York. All 3 of those would be different because they're different circuits. So that's when they're different, it's called a circuit split. And it's often the cases that the Supreme Court actually hears, because they have discretion over what they hear, are cases where like 2 circuits just don't agree on how you should interpret the law. All right, we made it through federal court. I swear that the really interesting cases are coming. We just have to get through all the background because it's not really as interesting unless you know it. But before that, all right, this one involves printers. So Lexmark v. Static Control Systems is a case where Lexmark tried to sue static control systems, which made like competing reloaded toner. They made like toner cartridges for Lexmark printers that you could buy because they were cheaper than Lexmark's under the DMCA. I'll note, in case this was not obvious, that Lexmark does not involve video games. But the reason we're talking about it is because their technological protection mechanism involved hashing basically the code of the program, the toner loading program, and checking it against an onboard number. So for the purposes of static control systems, they couldn't really use a different toner loading program. They couldn't program it in a different way or not use the copyrighted code because they're running a hash function on it. So if the code isn't the same, the hash is not going to return the same value. And so Lexmark says, hey, we copyrighted the toner loading program. You are you're infringing our copyright, and you are, by selling these toner cartridges. I can't even make it through the explanation of this case without kind of cracking up. Because they say, by selling these toner cartridges, you are trafficking in a circumvention technology in violation of 1201A2. This did not go well for them. The Sixth Circuit says, okay, look, this was really not what the statute was meant to do. And although your toner loading program may effectively control access to a copyrighted work, A, we're not sure it's copyrightable because the code is not sufficiently creative, but B, like, we're just going to choose to not read this as within the gambit of sort of what the 1201A2 is meaning to protect. There's no underlying copyright infringement. There's no real even underlying copyright interest. The only reason you care about copyright is because you don't want people to be selling replacement toners at lower prices than you. So the Sixth Circuit like is not buying this as a 1201 argument. The Eighth Circuit, on the other hand, came to a kind of different conclusion in a case that I'm assuming people are probably more familiar with. I'm sure your class has read this case, so I realize maybe I'm biasing my sample, but have people heard of this case before? Oh wow, okay, well this is exciting. So Davidson Associates is Blizzard, for those of you who were not aware. And this is the case, literally I get upset every time I talk about this. This is the case about private matchmaking services, servers for Battle.net. So Battle.net kept going down all the time, a problem that totally does not happen today with any server system produced by any game company. And so when it went down, after many times, a group of developers developed what was called the BNetD project, which was basically a private server system for Battle.net. It was just private matchmaking, like you could play with your friends. It was just an alternate server, and it communicated with your copy of Warcraft 3 or Diablo or whatever Blizzard game you wanted to play in order to let you play the game. The lawyers for the three programmers kind of screwed up the fair use issue lower in the court, so it doesn't come up in the Eighth Circuit, so we don't get to really deal with the fair use issue. But the other thing that happened, like sort of earlier in this case, before we get to this point, is the BNetD server guys, they were three guys, and when asked as part of testimony about like why did you do this thing, right? Like why was it worth your time to create this server? They were like, oh, we just did it for hack value. Which is like a totally reasonable thing to say to another human. Just like being like, oh, like why did you like, try to figure out how to like hack this program? Well, I did it for the lulz, right? Like say that to your friend. Do not say that to the opposing side's lawyer, right? Like I'm not giving legal advice. Don't say that. Because basically the judge is like, I don't know why you did this. I don't really care. You did not include the CD key check, right? The thing that reaches out when your Blizzard game reaches out to the server, it says, hey, is this a real CD key, and is the CD key currently in use? And if both of those, if the CD key is real and it's not in use, the Blizzard server will return it okay. BNetD obviously did not have a list of valid CD keys, right? So they couldn't be like okay or not okay value. And so that was the technological protection mechanism that they circumvented, both individually and they put the BNetD code on the internet, so they were trafficking under 1201A2. So this is basically the case about private servers in the 1201 context, right? It involves a relatively particular set of facts. But what I always keep coming back to every time I read this case is there was no way the BNetD developers could ever have done the CD key check, right? Like, this was just not a thing that they had as an option, because like it's not like they could have gone to Blizzard and been like, hey, we want to develop a competing service. Would you mind handing us all of the hash, like all of the CD key values that you use? Like, that's not going to happen. So they didn't really have an option to include the sort of to check the version of the game is real. And this is going to be sort of an ongoing theme in this area of the law, is that even people who are trying their best to stay within the law don't necessarily have the mechanisms to like fit within the copy control scheme that the video game companies would want them to. So Blizzard won. This is the 8th Circuit. It's 2005. And what's interesting about this is it's not, when you read the 8th Circuit opinion, it's not entirely clear sort of like what the copyrighted work at issue is. right? Like, it's clear that there's a copyrighted work because Blizzard, as we talked about, Blizzard's video games are copyrightable and registered with the Copyright Office. But, you know, was it allowing access to these video games? Was it allowing access to, like, the server code? It's something that I come back to a lot. I'll just pause it and move on to a case about garage door openers. You know, probably obvious, but I'll say it. Garage door openers, still not video games. So Chamberlain versus Skyling Technologies is the Federal Circuit case. And what it says is Chamberlain produced a garage door opener that had a rolling security code. This was a big deal as far as garage door security was in 2004. They were really worried about like hackers eavesdropping on, I'm not even making this up, hackers eavesdropping like garage door codes and using them to break into houses. So they developed this rolling mechanism, which like, hey, that's great. They copyright it. They sue Skylink for developing a like compatible garage door remote, right? Like it's a universal garage door remote that works with all kinds of different technologies. It doesn't use the rolling code. They use a different technical mechanism to make sure that the right code gets entered into the garage door. And they say, hey, the mechanism is the rolling security code. The copyrighted work is the rolling security code program, which like does not seem like an intuitive result. And the Federal Circuit, just like the folks earlier in the printer case, said, all right, guys, we realize that like the plain text of the 1201A2 may support a claim that this is access to a copyrighted work, but this is not what this was intended for. This is like basically like anti-competitive, right? Basically, they just don't want anybody producing garage door openers that work with their garage doors other than them. They want people to buy their garage doors. So what we're going to say is that trafficking in slingshots is a 1201A2 violation only if pigs, copyright works, are injured, right? And maybe we can soften it to say it's not only if pigs are injured, but there's like the potential for pig injury. We're anywhere near a pig injury, right? That like the world in which you are operating is actually related to some sort of right that is protected under the Copyright Act, right? So what Chamberlain says is that this is not like what the Copyright Act or what the DMCA does not do is give you sort of a general right against all folks who are circumventing access control technologies. It kind of has to be related to some sort of underlying copyright theory or copyright violation practice. And this is really important. In the next case, we'll show you why. So you're going to sense a theme here, which is that Blizzard is the bad guy in these cases. And that's probably just because they had active lawyers who were pursuing this. But in MTY versus Blizzard Entertainment, Blizzard sued a bot manufacturer, MTY, that was making a bot glider, which was a bot that would play World of Warcraft for you and like auto level. You could set it to a certain area and say, hey, I want you to kill 10 rats or whatever, and then kill 10 more rats, and you know, etc. It did it for you, right? So they first tried banning a bunch of bot owners, and that didn't work so well. So then they sued the company manufacturing the bots. And I want to note one sort of line from the opinion, because I think this is actually really typical of how some video game manufacturers deal with people in this circumstance. In 2006, Blizzard's counsel visited John Lee's home, threatening suit unless MDY immediately ceased selling glider and remitted all profits to Blizzard. So Blizzard's lawyer shows up at the house of the person who makes the glider bot and says, hey, can you stop? And the person who makes the glider bot said, like, what? Yeah, it violates your terms of service, but I'm not, you don't have proof I'm using it, I'm just selling the thing, right? And so MTY in this case actually sues Blizzard. They say, hey, we want to show you that what we're doing is okay. It's called a declaratory judgment. And that, you know, so because Blizzard's counsel, it's not like they, didn't have any reason to be worried about Blizzard suing them, right? Blizzard counsel literally shows up to this guy's house. And there's a whole bunch of different takes on what happened here. I think Penny Arcades is not as far off as it could be. I'll just fact check one thing about this comic, which is that nobody says ladies and gentlemen of the court, they say ladies and gentlemen of the jury. So I'm going to read to you what Penny Arcade claims would be Blizzard's opening statement in this case, which is, my client's concern that the World of Warcraft glider and other bots has nothing to do with copyright. We only said that because it sounded scary. That's like pretty typical to copyright litigation, to be fair. In reality, these bots represent a threat to the fundamental purpose of our game, which is to devour human lives. It pulverizes men and women while their babies die in a closet. Pretty harsh. These automated processes circumvent the shallow, mind-numbing monotony that is at the black heart of our product. In short, these bots are a teeny crack through which our initiated prey may escape. So I'll note that this was not Blizzard's argument. But what their argument was that they had a part of WoW called Warden that scanned the user's computer for bots, like stored during install, and then a resident program that scans the user's computer for bots during play. And they claimed that these programs were a technological protection mechanism that protected all of Blizzard's copyrighted works, right? So the thing to note about this case is that it's not even like MDY copied any of Blizzard's code, was copying any of Blizzard's files. They literally like developed an automated script to run in the game to play your character for you, right? So this is pretty far afield from the from the sort of rights that copyright is meant to protect. But nonetheless, they claimed that the copyrighted work that was at issue here was WoW's dynamic, non-literal elements gameplay, and said that under both trafficking provisions, MDY was violating their rights. And they win in the Ninth Circuit because the Ninth Circuit decided to read this the trafficking access control provision differently than the courts that we've looked at before. What they said was that the digital rights management thing just has to control access to a work protected under this title. If it controls access and you break it, you have violated DMCA, and you are trafficking in a tool, sorry, you have violated DMCA 1201A2, right? So, you knew this was coming, right? Oops, that's wrong. So trafficking in slingshots is a 1201A2 violation, even if no pigs are injured, right? Or, so that the injury, the copyrighted harm is just like totally unrelated to the right under 1201A2. So what you have is a circuit split on the access trafficking provision. In Chamberlain, there has to be a reasonable relationship to the rights protected under the Copyright Act to maintain a trafficking claim. In MDY, Congress just created a distinct anti-circumvention right under 1201A without an infringement nexus requirement. So like, wow. All right, that was a lot of law. It involves some video games, so that's good. Why does this matter? So there have been a lot of cases that have happened after MDY. To characterize them very, very bluntly, I would say they are cases involving much smaller companies. They usually involve defendants that do not ever show up in court. So like people who are not in the United States or for whatever reason don't show up. And they involve mostly, sometimes console modding. This one actually, Nexon v. Kumar, involved a private server for MapleStory. The defendants don't show up in this case. There are statutory damages, which means that defendants who did not show up in this case and made approximately, the court thinks about $68,000, now owe 3.5 or 3.6 if you want to round up, $1 million in statutory DMCA damages for operating a private service. That's where this law puts us. This is a court like looking at the case law in the Ninth Circuit and saying, all right, that's where we are. It also means some other peculiar things happen. Jagex is a company that makes RuneScape, which has been around for as long as the DMCA. And they decided to sue Impulse Software, who is a bot manufacturer in the District of Massachusetts. That actually did not go well for them, although the judge made a number of mistakes in the opinion, and that sort of is beside the point. But what Jagex decides to do that's kind of unique, and if you know of any other examples, I would love to hear about them, is they start suing individual players who are running bots. They say, well, we know you violated our terms of service, but when you violate our terms of service, we don't really get much out of it, right? We can't like intervene in any way. Instead, they say, we will sue you individually so that we can get damages. They actually send this settlement letter, which a bunch of people think are spam, and so don't respond, and they have to post an update on their forum saying, no, really, we were basically trying to solicit you for money because we think you violated the law. I'm aware we're sort of reaching the end of time, so I'm going to speed through a couple of slides because I just got so excited about my case law. The other thing that happens is there are criminal prosecutions under 1204. You can be fined, you can be imprisoned. Skip that case. In USC Reichhardt, this guy gets sentenced to a year and 1 day in jail for modding an Xbox. So like, if you think that this is all like an interesting intellectual puzzle, unfortunately, A, it's not. And B, the sort of legal uncertainty means that even though it's possible that Reichhardt actually thought what he was doing was legal, he set up a separate business account and openly advertised his services on the internet, he's still convicted of a criminal offense under 1204. All right, so the other reason that this matters is because basically this case law that I have just described for you, the way that the 1201 has been implemented, has made it, I'm going to quote the report that Andy was talking about, impossible for a library to create a preservation copy of games employing DRM and anti-copy measures, which, as I think I don't need to tell you, is pretty much most to all games produced and sold by like major studios today. Like indie folks do all kinds of interesting things, God bless them. So basically, this legal regime has made preservation incredibly difficult to maybe straight up impossible. I tried to fix that along with the EFF a little bit. We moved the needle a teeny bit in terms of trying to get protection for people who wanted to who wanted to preserve video games. We got some sort of limited rights, which I'm happy to talk about. But why video games matter to this area of the law is because those cases, MDY and the VNetD case, don't come with a little like asterisk that says this only applies to video games, right? In fact, they apply to everything. And that's why Lexmark came out the way it did. So the law, although the case law sort of suggests the split between video games and not video games, which I've sort of architected, the law actually doesn't differentiate well between the printer and the video game in circuits where it's already decided. And so 1201, that access control provision, applies to the software in your car, the software in your tractor, and the software in your medical devices. It also applies to your Wi-Fi light switch and your Wi-Fi water pitcher. That's the future. Thank you. Sorry, that was not optimistic. I think Josephine promised more optimism than actually happened.
Great, that's a perfect recap of what we tried to put in our report. It's fantastic. The world is grim and then they all die. Awesome.